thank you all for coming here. Eve, you want to come up here? Where are you? We do have a little show and tell. This year I had a bill on transparency in government. It's a subject I've addressed before in one form or another. And through my role in the Senate, I've met several of the panelists that we'll have with us tonight. And as someone who believes very firmly in that the owners of our government are the people, I believe very strongly in openness, particularly in government. And we have occasionally encountered issues where we butt our head up against private information of individuals that is in government hands. And you'll hear from several folks tonight about the conflicts that brings to the fore and how various people think we ought to handle them. I'm going to try not to interject myself too much, but I want to share with you a little bit of what I learned in our process this year of putting in a bill that would have required a great deal more disclosure by the state government of its budget and its expenditures, and those are not always the same, which often surprises people, but the money can get moved around quite a bit legally. And what Eve is going to do here is go to the Virginia Data Point website, which was put in place several years ago as intended to be an openness site. When my bill came in, the public auditor who runs this site testified before the committee we were in front of that they blocked Google from their database. And you might say, well, why would anybody block Google from their database? Google has found that people search for government information more than any other kind of information. And so in Virginia, we're blocking Google from allowing you to do simple searches the way most of us are now used to doing in the government databases, at least the compiled databases that are intended to be for openness. And his reason was that Google would crash their site at night with the spiders they would send to index the site. It was a bit disappointing I wasn't on that committee, but it seems to me somebody should have asked the question, well, if your site is so good that Google is crashing it, why isn't anybody else's site crashing? And but no one on the committee thought to ask that question. In the world in Virginia, there are a lot of well-intentioned people and I don't think we're doing the best job in the who do the best they can in this area, but we have a long way to go. Eve is going to, if you go ahead and walk through it, I'm going to talk it through. Eve is doing a search here on the Data Point site for Cisco, not the computer Cisco. These are clothing sales that we happen to already know, so I already have a jump on it a little bit. And what we found as we went through here, you can see all the blue dots at the bottom, they're all too small. Those are the returns on the search. There are over 25 different pages of returns, but they're not sortable. You can't, there's not a lot you can do with them. And thank you. 2,513 pages. Now, Google would rank those. Ad hoc searches would rank those. We have no rank, we have no context for any of this, and it's very difficult, even when you get to a piece of information, to understand what it means. For instance, you can see charge card account, $32.75, Braddock Road, Sunoco. Well, you can probably guess that somebody bought gas there, but you don't know who, you don't know why, you don't know where they were going to or from, and you know, who knows, maybe they live around the corner and it wasn't actually a state vehicle. But not to be paranoid or anything. But again, you know, that's the kind of thing that I think the owners of the government, you all, have the right to poke around and look at if you so choose. I think that probably the only reasonable limits on this approach when you're dealing with individuals' information. The way we're going to operate tonight, after we poke through some of this, is we have 5 speakers, as you can see up front. Each of them is going to have 10 minutes to address this topic from their own perspective. We have our friendly neighborhood timers up here, and if they aren't sufficiently adequate with their 10-minute warning, I'll be pushy. And after each of our speakers has had an opportunity to address the topic from their own perspective and their own experience, then we will conduct some question and answers, starting first with members of Prince William County Committee of 100. And I'm going to circle around, so you won't get your second question until everybody that wants to gets first. And folks in back will come in at that point, and any media that's here as well. I may toss in my own questions once in a while, but when we do get to the question and answer period, there will be a microphone available, and we would ask you, for purposes of ideal audio and video recording of this event, to use the microphone, please. And I will thank you in advance for that. We appreciate it very much. When you do speak, please give us your name so we know who we're hearing from. And that's the ground rules that we'll operate under. And let me, if I may ask the panelists, come up, grab your glasses of water, and come on up. I'm going to go ahead and introduce our first speaker, which will be Cheryl Chumley over here. She's a reporter, and I will tell you all that the packet, every table has a packet, has the background for the panelists. One of the first things I do when I'm reading an op-ed is I look at the background so I understand the perspective, and I'll give you a little introduction for each person, but there's more detail that I'm going to give you in those packets. Cheryl is a reporter. She's been nationally recognized for her work in Fauquier County, I believe it was, on the Freedom of Information Act and associated topics. She is going to be our first speaker, and I'm going to go ahead and turn the mic over to her. Eve, you are relieved. I would encourage you all to go to Virginia Data Point yourself, see if you can figure out how to do a search, and you'll note the little warning at the bottom. It says searches take 1 to 5 minutes. Time your Google search to find Virginia Data Point before you do that one. You can tell my opinion of that. It took this long to get Northern Virginia Training Center results. It's across the street from the Fairfax Cemetery. It's where Cisco makes some sales. There are 80 results, and we'd have to download them into a separate table and go deal with them separately to search them at all. So that's the quality of what we have in Virginia at the moment, and unfortunately we have a long way to go. But nonetheless, I'm going to turn it over to Cheryl, and go first. Yeah, just turn the mic over to you. Okay, whichever you're more comfortable with. Just be careful of the water. Electrocution.
Hi. Can you hear?
No.
Is it on? Switch ways.
Sorry.
Close to the mic. Close.
Or pull it closer. My name is Cheryl Chumley, and first up I just want to thank the Committee of 100 for giving me the chance to speak about one of reporters' biggest tools, the Freedom of Information Act. Most reporters use FOIA primarily as a means to an end, as a way of getting information and documents, records, so they can write their stories. And I do that too. That's a big part of what FOIA is about, to get documents and records. But I guess it's been my experience through the years that the process of getting the information has seemed to turn into a story in itself. How government responds to the request, how government provides the information, whether they uphold the law or not, that to me has always been part and parcel of general reporting. If government stonewalls on a FOIA request, isn't that as important to report as the main story? At least that's how I've always thought. I've also always thought that FOIA was a true people's law. It's not a media tool that gives reporters any special privilege. It's not a law that creates a special club among reporters and the people they cover. It's basically a law that gives the average citizen the right to walk in and off the street and request the information that they want, and that basically they pay for with their taxpayer dollars. It dictates how government has to respond to those requests for information, and more often than not, that response should be, here you go. As a reporter, I've requested on a regular basis things like travel receipts, draft copies of meeting minutes, draft copies of proposed land use ordinances and policies, copies of emails of board members, pay and compensation records, Probably the most controversial is the names and salaries of all the Prince William County School employees, which I'm sure we'll get to during the question and answer period, so I'll just skip over that for now. But it's important to note, too, that FOIA guides how meetings of government bodies are to be conducted. And for the most part, it's in the open. There's certain guidelines for closing the meeting to public attendance. Briefly, FOIA says the public has to be notified when government bodies meet. They have to be given the time and location of the meeting, and to hold a closed session, they have to hold an open session first and let the public know why they're going into closed session. Sometimes government bodies don't do that in accordance with FOIA. And from my perspective, it seems the most common mistake government bodies do is they fail to give enough information about why they're going into closed session. They cite the code, for instance, as FOIA requires, but then they don't give any more specific, as FOIA also requires. For instance, if a body wants to go into closed session to discuss a legal issue, which is allowed by law, they should also tell what the legal issue is, which FOIA calls for. They need to cite the case, give a little bit more information to the public, so the citizens are able to determine for themselves if the closed session is held in accordance with the law. Without this bit of accountability, bodies would go into closed session all the time, discuss whatever they wanted behind closed doors. But like I said, a lot of government bodies fail to uphold this part of FOIA. And for that, there's a process that citizens and reporters, of course, can follow in order to hopefully let the elected or appointed know that they're doing wrong. Anybody can challenge the closing of a meeting, not just reporters. You just basically stand up and say, I challenge the closing of this meeting. It's a little awkward, everybody looks at you, but at least it puts the body on notice that you're paying attention, and it also causes them to reconsider, or at least it should. The advantage reporters have when they challenge the closing of a meeting, of course, is they can turn around and write stories about it the next day, which I've done pretty often. And I wanted to run down a few of these examples of stories I've done over the years. Basically, I want you to see, first off, how FOIA works on a day-to-day basis of government operating daily. But secondly, I want to show what citizens, not just reporters, but citizens, can do to take action when they feel their officials aren't acting in accordance with the law. That sometimes even real change can occur. The first example I wanted to go over was the Board of Zoning Appeals that I covered, and they held site visits where they all boarded a van. Basically, they used to gather at a certain parking lot each month prior to their afternoon meetings, board the van, and all members, usually the full body, sometimes just a quorum, but always at least a quorum, they would board on the van and talk about the cases. I knew this was happening because a staffer who rode the van tipped me off. To me, once they all boarded the van and began to talk about the actual cases they were covering that afternoon, that constitutes a public meeting. You had a quorum, you had them discussing public business, and it should have been, to me, in my perspective, it should have been advertised in accordance with FOIA as a public meeting. So one day I went to the parking lot of when they were having a meeting, and I challenged the meeting. I challenged their boarding of the van. I addressed the chair of the board, but soon after the board's attorney came over and a few members, everybody had to get a listen. That day they still boarded the van, and I ended up following in my truck, and I went to a couple of the site visits, and I listened while they did discuss business. So that just proved that they were going on site visits as a quorum and discussing what should have been discussed in the open. So when I wrote this story the next day, I wrote it from the perspective of a FOIA violation had occurred on the part of the BZA. What resulted finally was the BZA did start advertising these site visits. They put it on their agenda, their time and location that they left. So anybody with interest could follow. Or they could ask to board the van and partake of the discussions that the board members were doing. The second example I wanted to talk about was the Board of Supervisors' trip to Legislative Day. You're probably all familiar with Legislative Day. It's it's an annual event. It's set aside a couple days each year. I think it's in January, where county governments go down to Richmond and they do training, but it's also a set aside special time for these county governments to meet with their delegates. Usually the boards meet with delegates over dinner, and they sit down and they discuss informally. Basically they're not supposed to discuss matters of public business, because then that would constitute a meeting if a full quorum was present. But unless you're the type, if you're that bold enough to break in and bust up someone's dinner, I would say you'd have to give them the benefit of the doubt. But this particular board, instead of holding a dinner, they set up, they rented a second hotel room, And they actually invited their delegates to come to the hotel room, and I knew from my research before Legislative Day occurred that they were planning on discussing certain legislative affairs, bills, policies. So in my view, that constituted a public meeting, one that should have been advertised. So when the Board of Supervisors left for Legislative Day, my story in that day's paper was about how the board was leaving under a cloud of suspicion about FOIA violations. And then I traveled to Richmond to cover the actual meeting in the hotel. I ran into the county administrator. I got the room number from the hotel where the meeting was going to be held. I went to it. A couple of the delegates did show, and in fact, they were discussing business. So I stood by my story that this was an actual public meeting that should have been advertised. The board didn't agree, but I did notice the following year they put out a flyer, and they also advertised on their calendar internet site that anybody with interest in attending could go at such and such a time down to Richmond and meet in such and such a hotel room. The last example I wanted to go over is a part of FOIA that deals with the Chief Executive Officer. There's a part in FOIA that gives the Chief Executive Officer in a county government the right to hold informational gathering meetings. It's kind of important to keep an eye on this area for abuse. In this one case I was watching, the county administrator was holding these meetings with various invited environmental officials from the state, from local government, and from local environmental nonprofit and activist groups to discuss a range of land use environmental issues. Some of these issues, I learned, were the same that were being discussed later by county boards and planning commissions to develop policies, ordinances, and regulations. Still, I guess that would be okay if the county administrator was just using this for his general awareness or to gather information to pass on to the board later on. But this county executive had been doing this monthly for 2 years. And that seemed to cross the line to me. Instead of just holding a simple gathering to get some information, background information, the administrator seemed to be holding regular meetings that should be advertised in accordance with FOIA. The county attorney didn't see it this way, and in fact it got to the point where I was going to send the information to the FOIA Advisory Council for a ruling. But following a story I did highlighting these issues and putting them in perspective with FOIA, the county did begin notifying the public of these monthly meetings, and anybody with interest could attend. Just in conclusion, these are but a few examples of how FOIA can be used on a daily basis to keep government in check. On one hand, you might look at them and say, so what? What's the big deal? You know, writing a story about a government body holding a meeting in a hotel room, or asking that they give a proper and lawful exemption before they go into closed session. And on top of that, I can't tell you how many times I've heard and even believed these same county officials who I've confronted over FOIA, they would turn around and say they didn't know they were breaking the law, they didn't mean to, and they thought they were acting in accordance with their constituents' best wishes. Well, here's my answer to that. The opening section of FOIA says in black and white that government officials be handed a copy of FOIA and that they familiarize themselves with it when they take office. So ignorance of the law is no excuse, nor should it be. A fundamental role of government is to uphold the laws of its citizens, and if officials don't know the laws, how can they uphold them? Secretive and oppressive governments don't spring up overnight. They come in small steps, often led by people who genuinely believe they're acting in the best interests of the public. But if nobody's going to take a stand on the small things, then pretty soon government won't feel accountable to anybody at all. And as far as my perspective as a reporter goes, I can only say that I'm just the messenger. Really, all these examples of stories I've written dealing with FOIA were aimed at giving people the knowledge they need about how their government acts when confronted with the law. But the media can only do so much, and it's the people who are the real enforcers. Thank you.
Our next speaker is Maria Everett, somebody who I've gotten to work with in my role in the State Senate, because Maria is the executive director of the Virginia FOIA Council, which has been in existence 8 years this year and has issued closing in on 10,000 informal opinions, as well as, I believe, almost 200 formal opinions. And Maria's been involved in a great deal of that herself, and she is at the nexus of all things FOIA in Virginia. And it's my pleasure to introduce Maria Everett.
Thank you, Senator, and good evening to everyone. I'm really happy to be here. And first, I want to take an opportunity to say, Cheryl, that was great. You showed a great knowledge of the law. In my job with the FOIA Council, we are a state agency in the legislative branch, and really my job is to be an educator. And so much of FOIA for everybody is still misunderstood. And so I find, I don't have prepared remarks other than to do a little education, because all of us have heard the words FOIA, we've heard freedom of information, but precious few of us, whether we be citizens, whether we be government officials, or the news media themselves, really understand what this law actually requires. We all have our perception of what this law says, and so tonight I'd like to just talk about what this law really requires. I think Cheryl did a great job of her understanding of what the law actually requires, and I applaud that. To dispel the myths of FOIA, that again, we perceive it to be something. And FOIA is not a law that allows citizens to tell public officials what to do and how to do it. The Freedom of Information Act in Virginia has two parts. There's the open records part, and there's the open meetings part. The open records guarantee is ready access to all records in the possession of government. And a public record is basically, if we have it on the government side, it is a public record by definition. The question under FOIA is really, does that public record have to be released? Under the Virginia Freedom of Information Act, there are 126 exemptions from records. And that may sound like a lot to you, but when you hear other government officials talk, the presumption is that every record we have, regardless of physical form, whether it's an audio tape, a videotape, a map, a picture, handwritten notes, databases, it's all presumed open for the asking. And so what FOIA recognizes, though, is it's a balance of the right of access, which is citizens and the media, against the need of government to function. So sometimes the government kind of wins. Not often, but there are times that most government officials were hired or elected to do a variety of things. FOIA is obviously part of that job, though it's in that other duties as assigned category that they don't tell you about until you're actually doing it. But what it recognized, the balance of FOIA, is the right of access against the need of government to function. And what FOIA exemptions are about is recognition that there are times, appropriate times, that government can play it close to the vest. It's in the public interest, whether it's protecting bargaining position when we're negotiating contracts, buying or selling real estate, when we're in a litigating posture, personnel, medical records, scholastic records, where there's a privacy involved when we're negotiating contracts. So government can hold it close to the vest, at least temporarily, while the negotiation, when there's a bargaining position or a negotiating posture to protect. And that is still in the public interest, because the story would be that the Board of Supervisors talked about they were looking at 5 different sites to buy land, to put something public there. If I happened to be the owner of the land and I knew the county was coming looking to buy my land, would the price of my piece of property go up? Absolutely, I would tell you frankly. And then the story would be written, you blabbermouths, you talked about all the different sites you were looking at, and you had to pay more than you otherwise would. So that's one of those balances that FOIA strikes. On the meeting side, the guarantee is to afford every citizen every opportunity to witness the operation of government. Now, when we talk about witnessing the operation of government, it is deliberative bodies. We're talking about the school board, the Board of Supervisors, the Board of Zoning Appeals, the City Council, you name it, the Planning Commission, any deliberative body, which is a certain subset. When the records world we're talking about in FOIA is everybody who is a public employee or an elected official or appointed official. In the meeting side, it's the deliberative bodies. It's the advisory bodies, the policy boards that we have the right to watch. Deliberative bodies must deliberate in public. And all too frequently, once they're elected or appointed, unfortunately, elected or appointed members tend to say, okay, you put us here, thanks very much, now you all go home, we'll take it from here. They don't realize that's the beginning of their exposure. The public service is the hot seat, there is no hiding place. And I tell elected and appointed officials, if it seems a little too hot to you, nobody put a gun to your head and said you must serve. So the idea in the meetings world, and Cheryl's talking about that, is closed meetings. Again, protecting a bargaining position. You're negotiating a contract in closed session. You may be talking about litigation in closed session, but she's absolutely right. There's a process by which you go through. And that's what this law really is. It's a process. It's predictable behavior by government. And let that just wash over you for a second. What? Predictable behavior by government? Yeah, and that's what it's trying to do because, and I apologize to some people who've heard me speak before, but the idea is after lawyers, people hate the government the most. And they think we're a bunch of losers who have nothing better to do than make it hard for you. And I'm here to tell you that is not true in the general rule. Of course, you find bad apples in every basket, but the idea of FOIA is predictable behavior by government. In the records world, it is responding in a certain period of time and that form of that response. In the meetings world, it is holding open meetings, having motions to go into closed session to at least notify the citizens why they're being kicked out of the room and why they're going into a private session. So it's when you stop and think about FOIA in a larger sense, it's all about government of, by, and for the people. And all of us embrace that notion and uphold it. But precious few of us really spend time thinking, what does that really mean? Okay, we elect officials. Okay, we got that. That's government by. But when you stop to think about it, that's what FOIA is. It's the everyday application of government of, by, and for the people. If it's truly our government, then this is the process by which we have access to the government. So it is an important law for that purpose. But like I said, it's unfortunate that a lot of us really don't know what the law does. But then in our defense is we don't hear about it in school. I mean, I went to law school. I never had a FOIA class. But that's the point of the law. And let me just talk a little bit about closed meetings. And there's no limit under FOIA. You don't have to go into a closed meeting, but you're allowed to, again, protecting a bargaining position, playing it close to the vest. Now, FOIA requires, again, this is a procedural law. It's the process by which government acts. So to close a meeting, you have to have three things, three elements. You have to have a motion that states the purpose of the meeting. You have part of it that states the subject of that meeting and the relevant code site. And the idea with a closed session is, with the motion, is to give the citizens notice, again, why they're being kicked out of the room without giving away the store. So that's sort of the bargaining position. And what sometimes can be the hard part of really working out the motion. And so the idea of purpose, well, FOIA tells you purposes for which closed meetings may be held. Contract negotiation, personnel discussions, litigation, economic development, those are the purposes. And the code site is always the same. So what public officials have to come up with is the one thing, subject. And in the world, subject and purpose sound remarkably alike to me. So what is the difference? Well, the law tells you purpose, so the law is giving you 2 out of 3. You just got to come up with a subject of what that closed session is. And the mistake that's made is that they don't talk about the subject. Now, do they have to go in grueling detail? No, but it's enough to let you know. And the example I use, school board example. The motion is they're going to go in and talk about disciplining a high school principal. So the purpose is personnel. The subject is disciplining high school principal under 2.23711. Okay, in Fairfax County, that motion is not giving away the store because there's like 4 billion high school principals, okay? And the subject can change because, again, you don't want to give away the store, you want to give enough notice. But in a county like Highland County, Virginia, if you make a motion that you're going in for personnel to discipline a high school principal under this section of the code, there's only one high school principal. Everybody knows exactly what's happening. So the subject can move a little bit. So the subject in that scenario would be the disciplining of an employee of the school board. The FOIA Council is here as a resource for everyone. We're not a media organization, we're the government, and it's our job to answer anybody's questions. We have toll-free numbers. I brought some cards, and please call us with any questions. We're happy to come and talk about FOIA. Thank you.
Thank Maria, and I particularly appreciate the implicit comments that you have to keep your eye on elected officials even after they're elected, maybe especially after they're elected.
Yeah.
We have a couple of school board members here. I'm here. I think I saw in the back Senator Barker walked in here as well. And I would note, I told you all about the bill I brought this year. In the committee meeting, Senator Howe, who's been there 25 years or more, lost track of that, said publicly that he was offended that I would bring such a bill because it implied that we weren't already open enough. So that inherent resistance among some elected officials is very, very real. Our next speaker is Ross Horton. Ross is the county attorney here from Prince William County, has been with the county attorney's office for quite some time. And Ross, you're up.
Thank you, sir. My perspective is obviously a little different from other folks. I'm at the local level, and we are the primary target of FOIA. The intersection of the people's right to know and the interest of individuals in society in preserving a sense of privacy in the information age is something that society will have to balance. On the one hand, an informed and vigorous population is absolutely critical to a democratic society. It's imperative that the citizens know what's happening in the county. It's imperative that they can make their views known to their elected officials. If the citizens have no idea as to what's going on, how are the elected officials supposed to respond to their needs and concerns? On the other hand, we're in a data-driven society, and the collection of information by governmental entities and others is substantial. Some of that data relates to individuals and includes information that some individuals would much rather remain private and secure. You would be absolutely astounded at what is available on the internet if you have never had to go out and actually look at what is available on individuals, and what is available in governmental databases is even more astounding. Identity theft is a real threat today, and it can lead to financial difficulties and economic disaster, and that's true both of individuals and companies. The Freedom of Information Act tries to draw a balance between these competing interests. It provides that it's to be liberally construed. If there's any doubt, the construction of this statute is to provide the document to open the meeting. Meetings by the public bodies are open unless there is a specific exemption either under the FOIA statute or some other law that says otherwise. The same is true of public documents, which are presumed to be accessible unless there is a specific exemption, and exemptions are supposed to be narrowly construed. Now, you should note that the FOIA law does not require that documents that we could otherwise exempt must be exempted. It is not a privacy law. If there is a document that the county could say, oh, we can shield this under FOIA, it's specifically covered in this section here, that does not mean that we cannot, in the exercise of our discretion, give it out. And sometimes we do. It should be noted that there are sections scattered throughout the Code of Virginia that make certain documents confidential, not necessarily in FOIA. An example, for example, is 58.1-3, which is in the tax section, which makes most of your tax information that's personal to you confidential. We have access to your state income tax returns. We have access to the personal property tax returns that you obviously turn in to us. Those returns have your Social Security number on them. We have lots of information from those returns. We can actually, in certain cases, get access to your federal returns in a proper case. That information cannot be made public. 58.1-3 makes it a misdemeanor to do so, and that's a good thing. The county takes its responsibilities under FOIA very seriously. It's critical to the trust that we're trying to maintain with our citizens. You should note that in the document arena, the vast majority of cases of citizens coming to the county and requesting information or documents are never reduced to a formal request under the FOIA statute. Their requests for maps, plans, policies, agency determinations, many other documents that are routinely dealt with by County employees at information counters, if you go to the zoning counter and you say, what's the zoning ordinance say about this? We give you that. It's never reduced to a formal request. Nothing's ever put in writing. And FOIA does not require that a request for a document be put in writing. It also doesn't require any magic language. You don't have to say, this is a request under FOIA. You can make an oral request. They can say, can you give me a copy of this? And if the answer is that it's not subject to one of the exemptions, the answer is yes, here it is. Now, as I said, you don't have to put your request for documents in writing, and most of them are not. Many of them are. Sometimes citizens will ask for a very broad request, and then we will ask them to limit their request or to make it more precise, and we'll sometimes ask them to put it in writing, which is not required, but they certainly may do so, in order that we can more properly respond to it. So if somebody comes up to us and says, I want to have every document that you have that relates to the Harbor Station development on the Cherry Hill Peninsula, and we've had that request, by the way, we can say, okay, that's going to cost you more than $200. Do you want to go forward? Or we can say, what are you looking for? Because we can narrow this down, because you're talking about tens of thousands of documents. And it's going to take more than the 5 days. In fact, it's going to take more than the 7 days afterwards. We're going to have to go to court because you've got this in probably every department in the county. And this is fairly significant request. 99 times out of 100, they say, oh, I don't want all that. This is what I want. And we respond. Another issue that comes up, and this is one that the FOIA, quite frankly, does not address very well, is electronic documents. We have lots of data in electronic form, some of which is a real document, like a Word document or an Excel spreadsheet or a PowerPoint. Those are easy. We can give you that document. Sometimes people will ask us to create a document. FOIA does not require us to do that. But if we've got the data in electronic format, theoretically, we are supposed to be able to provide that to them in that format. Sometimes it's easier and cheaper to write a program to extract that data, and we very often do that, even though we may not technically be required to do so. My office reviews hundreds of more formal requests for FOIA each year. It actually takes up the equivalent of about 1/2 of one lawyer for a year. That costs money. That's your taxpayers' money. We also expend the equivalent of 1/2 of the time of a lawyer responding to subpoenas for documents. Now, that's not FOIA as such, but it's still sort of sunshine. And these documents can be formal subpoenas issued by the clerk of court, or they can be issued by an attorney, and there are different rules that apply to those. It's very common in court cases between individuals, say in custody battles and divorces. It's very common in criminal cases where the defense attorney is trying to get around some of the rules on criminal discovery that prohibit it from getting discovery and try to go the end around. We have to file a motion to quash. It takes up an enormous amount of time. In addition to the request for the documents that are formally made, the county has an enormous website that you all should be familiar with. We have an enormous number of documents on the website. Everything from very basic budget documents, the same stuff the Board of Supervisors gets, to every Board of Supervisors agenda with all of the supporting documents is published on our website on Friday about 11 o'clock, just after the press gets a copy at a press briefing. It's available for everybody, and it includes every document that the Board of Supervisors gets except those that come basically from my office in closed session. Closed sessions are kept to a minimum, and I make sure that they relate only to those matters that are properly discussed. In the event during a closed session a member of the board tries to stray a little bit from the straight and narrow, it's my job to bring them back. And they're very good about responding to that. Localities are not allowed to conduct meetings by electronic means. This is probably a good thing, except possibly in emergencies in the event of a Katrina-type disaster, something that will ultimately have to be addressed at the state level. And then finally, as was previously alluded to, electronic communication between supervisors or other elected officials by things like email has always been a source of interest and issue. The Supreme Court recently addressed the matter in a case out of Fredericksburg called Buck versus Shelton. Email is okay, at least so long as it doesn't start resembling something like a chat room. If they're emailing back and forth and it ceases to look like letters going back and forth but becomes basically conversation, the Supreme Court would probably hold that that would be an electronic meeting and that would violate FOIA. Thank you, my time is up.
Thank you, Ross. Mike, skip that on down to Jennifer, if you would, please.
Oh, I go next?
I think that was the order we had. Jennifer Perkins is somebody I got to work with this year also. She is the executive director of the Virginia Coalition for Open Government. That position probably making her perspective rather clear. I will leave it to Jennifer.
Thank you. Thank you very much. And thank you all for coming. I'm glad to see people are interested in the topic. That's heartening to see. The difference between my role and perhaps Maria and some of the other people at the table is we are a non-governmental nonprofit that was started in order to aid the public, basically, in getting access to the governmental process. And the ways that we do that, and the easiest way to do that in the state of Virginia, is through use of the FOIA Act. So I basically am advocating for open meetings, people being able to attend meetings in all circumstances that involved public officials, and public documents to be open and available to the public. One of the main functions of our organization, which I think is probably the most important function, is that I get inquiries every day from email and also on the phone, anywhere from 5 to 30 a day, questions from citizens around Virginia on how to use their FOIA rights. Either they've been denied a document. Usually they don't come to me, frankly, until they've already had a problem. But so that's sort of my perspective of it. And I don't hear about all the times that they get, what they ask for immediately. Unfortunately, they come to me when they haven't received the document, or they haven't been able to attend the meeting, or they have a question about the interpretation of the act. So we spend a lot of time meticulously researching and answering those questions. We also have an annual conference to educate, and I spend time down in Richmond during the General Assembly session working on FOIA legislation, or what I call anti-FOIA legislation, which we also have down there. I think one of the biggest problems I see is a general perspective on public documents in the state of Virginia, and to a certain extent to public meetings. They are not owned by your town. They are not owned by your board of supervisors. They are not owned by your city administrator. And I think there's sometimes a feeling that I get from public officials that they somehow have ownership rights to the documents that they use to operate the people's business. And that's just simply not the case. We have to remember that their very salaries, their job, their purpose is to serve the citizens of Virginia. And the documents they use to do that with are so important for us to understand not only the decisions that they make, but how they come to those decisions. Because that's the interesting stuff, and that's the stuff where the public wants to weigh in and make sure they feel they're being represented in a way that represents the interests of the community. So it becomes a stance difference when you have a citizen who contacts me and is asking for information, and I have a government official who's trying to come up with as many exemptions as they can. And they are voluntary exemptions. You don't have to use any of them. There's other laws outside of FOIA that prohibit release of documents, but FOIA doesn't. So it's disheartening when I hear, and sometimes they actually call me directly and they say, can I fit this into this exemption? And I say, well, maybe you can, but do you really want to? So I think that that's a difference in stance. And I will also point out that there is information that I don't advocate to be out there. Social Security numbers we've taken a very clear stance on. We don't ever advocate for those to be out in the public realm, and in fact, we worked very hard on a piece of legislation this year that would require governments in Virginia to inventory why and where they're taking people's Social Security number, with the end goal of cutting down on over-collection. So then you don't have the issue of that land deed is up online and it's got somebody's Social Security number on it because maybe it doesn't need to, or maybe it needs to be redacted, which means just crossing it out before it goes on. And so there's definitely information, and there's health records and tax returns and certain educational records that are covered by other laws that we don't advocate to be out there. We're specifically interested in public documents under the definition of FOIA. I think the last thing, the last two things that I want to point out is I watched many times, and the gentleman, the county attorney spoke to this issue, that many times people are turning over records without any dispute. From our perspective at the coalition, that is the best possible result. If you can have, whether it's a reporter or an individual or a group of citizens, sit down with that public official and say, this is what we really are looking for, and this is what we really need to get this information, and work it out. For us, that's the best result. I don't encourage people to go to court because it's costly, it's time-consuming, and it may not get you a result that you're looking for. So we encourage people to sit down and negotiate and talk about what they're really looking for, and we also send people to the advisory council for an opinion from Maria and Alan to give you an idea of whether or not you have the law on your side when it comes to FOIA, whether you're a government official or a member of the public. And the last thing I want to say is, I get a lot of people angry at me and the group for advocating for records to be out there because they've heard of individual instances of records being misused, frankly, misused. And I think that the only way you can really understand the importance of FOIA is once you've needed to use it. And this year alone, I've only been on this job for less than a year, and this year alone, I've helped a woman get health records on her recently adopted handicapped child. I've helped someone else trace their genealogy. I have dealt with situations of deaths in the families and illnesses. I mean, there are so many examples I can't even begin to tell you all of why sometimes it's so important for you to get a public document. And it may even be life-threatening, and it may even be just really important for your livelihood. Maybe your job is in danger, or maybe there's something there that you need information on. So I think that FOIA sometimes gets a bad rap as being used as a media tool, and I'm here to tell you that every day I talk to people who are members of the general public and use it for very, very important reasons, personal reasons.
Thank you, Jennifer. And last but not least, Mike Stollenwerk chairs the Fairfax County Privacy Council, which also introduces them pretty effectively, so I'll turn it over to Mike. Thank you.
Thank you, Senator Cuccinelli. I'd like to recognize, I think I have two of my members here today. If you could raise your hands back there, Mark Helm and Andrea, my wife, who's required to be a member of the Privacy Council. Mark is from Prince William County, so we're an equal opportunity member list. If you'd like to be on my email list, it's fcpcchairman@cox.net. We have a website. But look, I was hoping to disagree with folks here today, but I agree with Cheryl. Local government especially tends to not follow the FOIA in some pretty obvious ways. I agree with Maria that the officials that run these localities should and probably do know better. I certainly agree with Ross that there's little or no privacy protection available to government officials with the FOIA, except for some strange carve-outs which are elsewhere in the code. It's a very anti-privacy bill. I was hoping to seriously disagree with Jennifer and attack her viciously tonight, but I'll only be able to sort of wing her later in my talk here. So first of all, FOIA is a great policy. In fact, it's used often by privacy warriors. I've used it myself. I sued Mayor Wilder down in Richmond after some festival folks said the city could authorize them to search people to attend the festival. I FOIA'd them, or the city. They refused to respond, so I sued them. Next thing you know, we never heard anything more about searches down there. Another one of our members, John Fenter, sued the Norfolk Airport Authority. That went up to the Virginia Supreme Court. It is a very important decision regarding you can't hide behind alleged federal authority to not answer your FOIA requests. Let's see, we have, yesterday I think a federal lawsuit was filed against the city of Norfolk by a guy named Chet Semecki, who was arrested for a gun ordinance at a festival that wasn't supposed to exist. One of his causes of action is violation of Section 7 of the Federal Privacy Act on unlawful demands for Social Security numbers by the police. How do we know they did that? Well, we FOIA'd them. We could prove it because they have a policy of doing that to people. So it's a great, FOIA's a great tool, and I think it should be improved. The issue of right to know versus privacy is kind of a false dichotomy. I don't think that adding some privacy to our FOIA is going to take away from the action of the FOIA. The idea is to have transparency in government. Show of hands, can I generally scurry around your local government, look for records on you, and if there's Social Security numbers in those records, generally does the government have to turn them over to me? Raise your hands if you think the answer is yes. Okay, you are the correct ones in the room. There is no general exemption for Social Security numbers or other highly sensitive information. I would contend alien registration numbers of our legally registered aliens, the good aliens, they are, those numbers ought to be confidential, just like Social Security numbers. There's a whole issue on that thing. And Senator Cuccinelli has introduced legislation on this in the past to try to get some privacy, and they're just on the edges that makes sense, as did Delegate Sickles, and these have been rebuffed. So while there has been some legislation this year in the area, I disagree with Jennifer. It's sort of window whitewashing the issue of we don't have some common sense exemptions. So again, false dichotomy. We just jump right into it. There is a constitutional doctrine of a right to information privacy. The Supreme Court said in 1977 in 2 cases that there is this right, this individual interest in avoiding disclosure of personal matters. And they held that in the cases at hand under the facts that although the government was intruding as a regulatory state ever creeps into our lives, they were at least securing the data in those cases, including a barbed wire fence around the computer servers so that your personal data would not leak out. And so that was held to be okay, precisely because there was an exemption from disclosing highly personal matters to the government. But even if we let the Constitution aside, just as a policy matter, there is a policy for privacy, whether it's identity fraud or just I have a right to be left alone or what have you. I think we'd all agree that we'd like our elected officials in Richmond to look at some privacy around the edges. So what are the ways we could do this? Well, one way is to go the way the federal FOIA, and about 1/3 of the states have done, and that is to set up a practice or a policy that just says, look, you don't give out information, or you don't have to give out the information when disclosure would amount to a, quote, clearly unwarranted invasion of personal privacy, unquote. And in these state courts and in the federal courts, they have basically sided with the agencies on things like Social Security numbers, dates of birth, in some cases home addresses, so forth and so on, and said that's excludable from FOIA. Now, some other states have added a strict, hey, no Social Security number, giving them out to everybody. But that's kind of like, half the ballgame. There are other sensitive information, including dates of birth, including other personal identifiers that we don't need to know just to know what government is up to. All right, so Ross went over income tax records, completely confidential. It's like, absolutely, you can't give them out. But strangely, personal property taxes, like your car tax and so forth, it's only a partial exemption of those fields. The government has to give out your name, address, and amount paid. Not what it was for, but name and amount and address paid. Is that absolutely horrible? No, I don't think so. I'm just trying to point out how we're living in an adhocracy in Virginia regarding the control of personal records. And I'll use that term, personal records in government hands. We would expect them to secure. Okay? Good news though. Delegate Sickles' bill, I didn't publicize it, snuck out. It's going to give us some date of birth privacy in the voting records. So starting 1 July, if you go down to your registrar, you can't just look up and copy down everybody's full dates of birth, which if you ask law enforcement, that is a very key, unique identifier that you can use to triangulate on someone and use it against it. Okay. Let's see. So, my conclusion, am I under warning yet? I'm fine? Okay. My basic conclusion is that, you know, this right to know versus privacy is not the main issue. It's a false dichotomy. We got other fish to fry in the land of FOIA. We have an unconstitutional provision in the FOIA that says that if your state citizenship is not Virginia, you can't apply. That clearly violates the Privileges and Immunities Clause of the Federal Constitution. That should be repealed. The Third Circuit has upheld that this is kind of black letter law. This is an easy one, although obviously legislation could be difficult. But it's wrong, and it should be fixed. Just, you know, we don't know everything. Our reporters here and our citizens might not have all the ideas that somebody in Tennessee might have. We have a problem with getting, especially local agencies, at least that's my personal experience. The state agencies, they click pretty quick when I call. But localities, there's a problem. Well, how do we enforce the FOIA? What's enforced with what's known as a private attorney general's action, so that you have to take your own money and hire a lawyer and sue them. And if you win and the judge feels good on that day, then you get your reasonable attorney's fees. Well, that's great, although the problem is if you have to keep going in, like I've done this once against Mayor Wilder, but my wife wouldn't let me do it again in Norfolk a couple months ago. So, you know, unless there's some way to sort of hyper-reimburse people, and I think the way to do that is to establish a liquidated damage penalty, say $500 or $1,000, that you actually get to keep in your pocket to enforce this. It might sound extreme, but just think of it. No court case is always going to come out your way, even if you're on the right side. Things happen, procedural problems, and so on average, if let's say you're going to win even 2/3 of the time, you're going to be out 1/3 of the time, and that's not good. So we need a mechanism, and I'm just throwing out one, to get greater compliance. A couple other things we can do in the land of FOIA that would be good. I'm sure a lot of folks at the state will have that. But privacy, adding some privacy to FOIA is not going to hurt transparency to government. And it's about time we either adopt a reasonable standard or an explicit standard and identify the fields of data. Thank you.
Recognize you. We do not have a microphone for those of you who were not lucky enough to be on the panel. So I'd ask you to speak up, please. For anybody I think it's necessary, I'll repeat their question so everybody else can hear. And please, we would like to get to a lot of questions, so try to keep your question short and to the point as best you can, and I'll try to keep the panelists' answers short and to the point as best we can. Follow-up questions are fine, but I'd like to get around to everybody first. I am going to start with the first question. I'm going to point at Maria, and that is with respect to quasi-governmental bodies, things like MWA, Metropolitan Washington Area Airport Authorities, or Metro. Can you explain to folks how Virginia's FOIA system applies to any of those bodies, and if they be different from one to the other?
Certainly. Our office actually has written an opinion that said MWA specifically, Metropolitan Washington Airports Authority, is subject to Virginia FOIA, because when you look at the compact, the trouble with interstate compacts is that they're all written for the benefit of each state that's a signatory, and so the idea is which is the law that controls that interaction. And in both cases, that Virginia law is to be followed. So, and the interesting part of, and I don't think that MWA and others like that quasi-governmental, under the FOIA rules, or the definition of a public body, it's any deliberative body that's performing a government function. So the idea of when MWA invited me over to do FOIA training to their security division, and I thought that was interesting since their lawyer's position was, we're not subject to Virginia FOIA, and I thought, well, so why am I here training you guys about FOIA if you're not subject? But clearly, it is our opinion they're an authority. Authorities are not necessarily traditional government. They're sort of floated out in one step to be a little bit more like government. I mean, like business in their dealings. They're not subject to personnel rules and certain procurement rules. But the idea is a more efficient operation, but clearly under Virginia law, they are subject. Virginia also grabs what we call really quasi-public bodies, or some nonprofits even, when we look at the dollar amount. That FOIA, not only traditional bodies, traditional government, but if you have a nonprofit like an economic development organization or the area agencies on aging that receive or wholly or principally funded by public funds, then they come under the umbrella of the public body under FOIA.
Thank you, Maria. All right, now let's get to you all's questions. Start with the doctor here.
Going to speak the mic or just speak
Just
out?
loudly.
Okay. My name is Dr. John R. Poswensky, and I have actually two questions, one short and one a little long. Now, I'm a little concerned here. Ross mentioned to me that the county, Prince William County, my county, is paying the equivalent of 2.5 lawyers to comply with the requests under the Freedom of Information Act. Can't the county get reimbursed? In other words, if I ask a question and a document has to be produced, could the county charge for these documents? So this way, me as a taxpayer, I'm not paying one whole lawyer's salary to comply with the law?
Ross?
The answer is we can legally charge the cost of copying and some search costs. We cannot charge for the time that my office might have to review documents. And so the answer to your question is we can get a little bit back, but not the bulk of it. And as a practical matter, we rarely charge. We do on occasion if it's a lot of money, if it's hundreds and hundreds of documents, we will. Generally, if somebody comes in and wants 25 pages, there's no charge for that. It's a part of the cost of doing business as a government. We have an obligation to provide this under the law. It's good government to provide the information to the citizens, and it's just part of what your taxpayers have to spend.
The taxpayers have to pay. There's no way you can charge user fees or something like that?
User fees?
Well, I mean, if they're asking for information, you're using it,
No.
pay for it. No, okay.
We can charge, we will occasionally charge like 25 cents a page, but generally we do not.
And I have a
Now, if somebody is asking for documents that are expensive to reproduce, if, for example, somebody wants copies of a roll of flats where it costs us $40 to reproduce it, we'll charge them for that.
Okay, thanks. Maria, just a short question. Is a community hospital come under this Freedom of Information? Like we have a Prince William Hospital, is a community hospital. Does that come under Freedom of Information Act?
If it's a hospital authority, yeah.
Hospital authority?
If it's not, no. I mean, if it's a nonprofit hospital, no. I mean,
Well, every hospital says they're nonprofit pretty much. I mean, except
well, yeah, but, you
everybody's
know,
nonprofit.
again, the standard there with what we call non-traditional entities, you know, government entities, where are they wholly or principally supported by public funds? And meaning government largesse, there's a budget appropriation to the hospital that's the FOIA Council's opinion, at 2/3, that's principally funded. When we give you money to operate,
So
and without which you could not operate, then you would become a public body. But
I know that Prince William Hospital gets money from the county, but you're saying when the contributions go to 2/3, that's the only time that it comes
Yeah.
out of it? Thank you.
All right, I saw one back over this way. There we go. What's your name, please? No, you just got to be
My
loud.
name's John Price. I'd like to find out the volunteer fire departments in this county are nonprofit corporations, but they're public funded through the fire levy. Is that under FOIA?
Maria, you want to take that one?
I get popular at this time. Volunteer fire departments, yes. You know, again, the locality is paying the operational cost of the fire department. Yeah, they do bingo and other charitable gaming, but that's, again, a portion of it. And what was the other part? Volunteer fire departments and?
No, that was it.
Yeah, they are public bodies if they're wholly or principally supported by public funds. If they get more than 2/3 of their operating budget as a direct appropriation from government, yes, they're by definition a public body.
Yes, ma'am.
Yes, my name is Jessie Barringer. I have a question about the state legislature. I've heard that some of these committees, either in the Assembly or in the delegates and in the Senate, have committee meetings. And in those committee meetings, they can either decide to report a bill out or to kill it. And the votes on those in those committees are never made public. Nobody knows who voted for or against. Should that be made public? And is there can we get that information through?
Okay. For those of you in back, the question was related to how committees in the legislature function in Virginia. In the House of Delegates, though not in the Senate, subcommittees do not report their votes in the same, they're not recorded votes. So people who are there and watching at that moment perhaps may be able to observe who votes in what way, but there is no recording of those votes, and bills that die that way are never heard from again. Unless a majority of the full committee votes to bring it up in full committee, which is very unusual. Because the General Assembly sets the rules for FOIA, I don't see the House of Delegates passing FOIA requirements on themselves that they don't provide in their procedural rules. And again, this is not done in the Senate. Every bill that gets voted on in the Senate is a recorded vote. Well, let me make one exception to that. The Rules Committee, I have noticed, and occasionally under our previous Finance Committee chairman, the Finance Committee wouldn't always record the votes. However, our rules do call for them to be recorded, which is obviously a difference with the House. So because the same body is operating under those rules as makes the FOIA laws, I don't think you're going to get one and not the other. So I'm not in the House of Delegates, but that's one senator's opinion. Yes, ma'am.
Hi, I'm Brian Altman. I live in the Coles District. And Mr. Horton, I liked your answer about how you structure the pricing for FOIA requests. But my question is kind of general. If an individual makes a FOIA request, how do we know that the amount that we're being asked to pay is realistic? What if somebody tries to block us and say, well, that's going to be $5,000, and they know that person doesn't have the money? What is my right at that point?
You can certainly write me personally.
Just bring it closer.
In that case, you can certainly write me a letter personally, and I will take a look at it. As a practical matter, sometimes it's going to be a rough estimate. When we get requests that are very broad, and sometimes the requestor is a little reluctant to specify more precisely what they want. In that case, we are required by the FOIA to give an estimate, and it's just that, it's an estimate. And we can require that at least a down payment be made before pulling the records. Some of these requests are for thousands and thousands of pages of records. And we may or may not know how many that is until we get done. So is it a problem? It can be. The requester at some point has an obligation under the FOIA to specify, to request the records with reasonable specificity. Now, they may not know exactly what it is that they want, but they are required under the Act to provide reasonable specificity. If they don't, and we can't get them to refine it, and they still want the records, we have an obligation to provide the records under FOIA unless they meet one of the exemptions. We're going to provide those records, but at some point, the public is going to try to recoup that cost.
Jennifer, you want to add to that?
Can I speak to that issue? I wanted to speak to this issue because to me it's one of the biggest problems that I see day to day with FOIA. I believe, and I'm going to go right out there and say it, that the fees are used as a tool to discourage people from asking for documents. I've seen it very, very elaborate schemes of thwarting of requests, and I think there's a couple things that everybody needs to know about fees. One is that they're supposed to be reasonable, and unfortunately the word reasonable is one of those terms that we all define differently. And two is that they're supposed to be actual costs. We also have some opinions that have said they shouldn't be attorney costs. You shouldn't be using the highest member on your staffs to do something ministerial. There's a lot of opinions that have fleshed this out, but I think it's really important that we understand that the whole purpose of charging, and some states don't charge, and some states have exemptions for the first 50 pages, et cetera, et cetera. The whole purpose for charging is to recoup actual costs of duplicating, searching, that type of thing. And once you get beyond that, I think you have to be really careful. And you're allowed to ask for an accounting of those costs, so make sure that if you do get a number back that you think sounds a little outrageous, there's two possibilities. One is that you need a full accounting of what they're saying that all this money is for. But the other is that I will agree with the attorney that sometimes the request is too broad. And people don't do it intentionally for the most part, but they may not know exactly what they're looking for. We don't know how government operates, unfortunately, and that's part of the problem. So you may not know exactly what you're asking for. And if you can work with the person or the public body that you're requesting from about what you're really looking for, then hopefully you can get some relief that way. But secondly, there's further relief other than writing a letter to the person you're asking for the records from by going to Maria's council, the Freedom of Information Advisory Council, for an opinion on the issue. It doesn't cost you any money. And then there is, of course, a legal process in this state if you, again, think it's been an unreasonable charge.
Sir.
I'm Lloyd Redmond from Bridgeville District. I'd like to run two quick scenarios for Ms. Everett and Ms. Chumley. You've got clearly a deliberative body, and they engage in a teleconference. And then somebody is a scribe and makes a record of the telephone conversation and the agreements. Or you got an email canvas among the deliberative body. Now, are those emails and the record of that teleconference, are those subject to FOIA?
Cheryl, let's start with Cheryl.
Okay, go for it.
Maria's already go for it.
I have requested copies of emails before, and it's always been my understanding that they are subject to open record. You know, usually there's a cost involved with it depending on what kind of system they archive the emails on. So what you can do to, you know, if you have a set period in time, like say from July to August of a certain year, you can narrow the focus down. And you can also narrow the cost down or lower the cost by requesting, but they only provide you copies of emails that key in on certain hot words. Like, you know, you pick a couple words that you know the emails have to contain, and they'll give you copies of those. I missed the first part of what you said.
The first part was the teleconference, and then one of the deliberative bodies, the scribe, and makes a record of the conversation.
Yeah, if there's a record, in my view, I would always approach it as an open record document, and then leave it up to the, you know, from a reporter's perspective. I'll ask for it, and then, you know, while they're determining whether they're going to give it to me or not, I'll call Jennifer or Maria if I have questions, or some other people who are expert in FOIA, and ask, is this open record? But when in doubt, I always ask, and I bluff, whatever.
Maria, if I could interject a question here. There was a comment made about localities not being able to have electronic meetings. Who can have electronic meetings, by which I mean speakerphones or video conferences, that kind of thing?
Under our law, only state bodies can teleconference or have audio-visual meetings on the notion that state public bodies are geographically dispersed, so it's a lot harder for them, but there are pretty strict rules. The quorum of that body has to be physically assembled in one main location. The remaining members of that body can participate telephonically, provided where they are is also open to the public. Now, local anything can never have a teleconference on the idea that everybody's in the same place. I know in Fairfax County that's a little tough. I'm from Fairfax County, and going to Fairfax County Government Center is a lot different from where I grew up in Mount Vernon, but the idea still holds true that local bodies and regional bodies as well cannot hold teleconferences because they're from the same locality, and that's upon which it's based. So under the scenario of the gentleman's question is that somebody's having a teleconference on the phone, you're in violation of law just doing that if you're a local body at all. So really the state government can do it. And one thing I wanted to talk about with Ross saying, with the emergency, the idea that localities probably need to meet by teleconference. The FOIA Council has recognized that and recommended legislation this past session, which did pass. So July 1, if the governor declares a state of emergency, local governing bodies, school boards, any local public body may meet by teleconference, but without a quorum being present and without the members having the public open to the idea of some catastrophic something or other happened, and so they can't physically meet. So under that condition, they can meet telephonically.
Other questions? Anyone in the back? Yes, ma'am.
Michelle Turner from Mansfield District. I have a question about the definition of the word litigation when it's used as a FOIA exemption. When you say pending litigation, to me, I would think that litigation has been filed and that there is litigation that's been filed and it's going to be ongoing. But I know sometimes it's used to go into closed session when it's like possibly, maybe, someday, somebody might possibly sue the county on this, and so that's used. And I wondered, so what is the actual definition of what's actually litigation and what's pending litigation and what's not litigation?
I'll start it, and I'm sure Ross has something. It's under FOIA litigation, which means filed and pending. We don't have pending litigation. The other part is probable litigation. And as I train people, it's not the, oh my God, we could get sued for that standard. Probable litigation is defined in the statute as litigation by which members of the public body or their attorney has a reasonable basis to believe will be commenced against or by a named party. Okay, so it's more than, oh my God, it's a named party. Either the government's going to sue or somebody's going to sue the government. And just to give you a flavor how dicey sometimes FOIA can get is if you're in a public meeting and somebody stands up, a citizen, and says, if you do that, I'll sue you for that. Possibly that is probable litigation. That's certainly a named party. But if that same individual at every public meeting stands up and says, I'll sue you for that, then your probable just went out the window. But you see the balance that this law is in constant motion. So have a little mercy, because it really isn't supposed to be adversarial.
I would agree with everything that Maria has said so far. And I would also note that the exemption for going into closed session for legal matters is broader than just litigation. There's also a provision for other issues where they have to receive or are entitled to receive legal advice on a specific legal matter.
I don't know if the rest of you did it, but I have the flash image of the person that I think of. I'm going to say if he does again. Shows up at every meeting. I don't know if everybody else was laughing at that same thing. Yes, sir.
Greg Gordon, Gainesville District. Is there any kind of distinction whether the person that is FOIA-able is a paid employee? Because there's a lot of volunteer citizens committees. Would they have the same responsibility to?
Just a minute, Ross. For those of you in back, the question was related to whether or not the FOIA ability of anything relates to whether or not individuals involved are volunteers or paid. Then I'll ask Ross to.
I'll take it first and then Maria can jump in. If the committee is appointed by the governing body, if it's an officially created committee as opposed to an ad hoc group of citizens that wants to just address the board. But if it's an entity that was created by the Board of County Supervisors, it's subject to FOIA.
I'm going to jump in and lob a question unless you have more to add to that, Maria.
Well, I only wanted to be clear in terms of, yes, that would be a public body, but the fact that you're not paid, but you're on a citizen advisory group that was appointed even by the administrator, certainly you're not subject to the meetings law. If that citizen advisory group that was appointed by the executive. But any record that citizen advisory group has produced is open record under FOIA.
Mike, I'm going to lob a question at you. This year we had the question arise out of Roanoke and Fredericksburg related to the publication of concealed carry permit names, and home addresses. For those of you who don't know Mike, I do. He is also an advocate for the Second Amendment, and there are a couple of different issues that cross currents here. And Mike, if you'd address just some of the competing interests there on a situation like that, particularly for those folks who have personal security reasons to be getting concealed carry permits.
Well, I'm sorry, I'm only here doing privacy today, Ken. Sure. It's kind of funny. Right now, there are 2 more states looking at closing off their records of concealed handgun permit holders, bringing the number to, we think, 29 if these 2 states do it. So the majority rule is sort of like driver's licenses and passports. We all heard about, even a contractor snooping in Mrs. Clinton's passport files, a huge problem. Whereas most record systems in Virginia, anybody can snoop in them about you. But the question is, do we put concealed handgun permit files in that sort of category like we do in Virginia for driver's licenses, like we do for income taxes? And so if you're on the receiving end of reading your home address in the newspaper, I think your answer is going to be yes. I don't want my home address and so forth published in the newspaper or snooped on by everybody. But it's a little more complicated than that, because there's kind of a historical artifact in that our concealed handgun permit files are at the courthouse. Because in the old days, you sort of made your case to the judge, and for good cause you got a permit. Well, because a lot of judges didn't give good cause rulings, or some gave it to everybody, finally the General Assembly set out criteria, and they said, okay, if you pass this criteria, you get the permit. But it's still, the judge now rubber stamps these. There's like 150,000 of these permits running around, and there's a dual system of records. One's at the courthouse, which is presumably always open for public inspection because, well, it's the courthouse. And then there's another sort of smaller file that's sort of a summary that has historically been kept by the state police, and it's been given out by FOIA for a very reasonable cost. So a bill came up to close off the state police, which arguably is closed by the Attorney General's opinion, but it might fail if challenged in court. So it was pointed out that, if you only close off half, and you can still run down to the courthouse, and if you're LexisNexis or if you're a stalker, well then for you the transaction costs are small. You can go down and dig through that file, which has a huge amount of identifiers, not just your name. If you don't read the Privacy Act warning, you might have put your social security number down. It's got your alien registration number if you were an alien. It's got your breast surgery scars. If you're a woman, you had breast surgery. It's got all kinds of stuff about you that probably meets that constitutional or certainly policy standard of you shouldn't do it. So, the question, and the bill's been held over, the question is, do you go whole hog and close the thing off? Do you close off one half but leave the other open? Or option 3, do you maybe to limit the fields of data and say, well, just names, like Texas did for a while, although I think they closed it off completely, or name and mailing address. See, the gun rights people want the mailing addresses because then, they can do things with that information. They don't necessarily need the home address. So all these things are on the table now, and it's kind of complicated. In the grand scheme of things, you get a permit, maybe your name being a public record is one thing, but when you throw all that other information in, especially your home address, especially if you're a stalking victim or what have you, that's not cool for those people. And I remind you, we live under complete adhocracy. Depends on the system of records. Driver's licenses, oh my God, it's completely confidential. Oh, concealed handgun permits, oh, you have. Here you go. So it's a hot question for the General Assembly, and I don't know what the answer is going to be. Okay.
At the moment, nothing passed, so the answer didn't change. I will tell you, in the Roanoke Times last spring, put the whole state list on its website. The same day, I got a frantic email passed up to me from a woman who had successfully hidden from her ex for 2 years, stalker, violence victim, who had a permit to protect herself, and he found her that day, called her that day, and that was the beginning of a trail of emails that I got that were very similar. Maria?
Can I throw a little counterpoint to that? Got it. Just wanted to throw out another idea.
I hear you. It's not on.
Is it on? No. Now it is.
It's much more open forum of
right.
discussion.
Exactly. Just a counterpoint to what you've heard is the recommendation to seal what we call the mother lode at the state police because it's a database was a recommendation of the FOIA Council, which is an odd place to be. But the idea is for all the stalkers, people, vulnerable populations, certainly we can protect them. But think about this for a minute. You have a teenage son or daughter that's going to babysit. Maybe you want to know that the people that they babysit for, whether they carry a concealed permit and there are guns in the house. Maybe you're an employer and you want to know if the guy's packing heat that you employ is a delivery guy because you have certain liability if they act badly with that gun. So Mike is right, it's a complex issue, but don't people throw out identity theft, you know, fraud, all these things to scare us in a way so we shut down records. But I can offer you the counterpoint to that. And also, let me ask this question. How many people are in the phone book? How many people can I call in 411 and get your name and your address and your telephone number? Have you ever Googled yourself? So let's keep the balance at, where that balance point is, but there are legitimate reasons. And the last thing I will say is government exercises for the public health, safety, and welfare. So if you have a license, I do, I'm a licensed attorney, you have a right to know that I have a license and what my name and address is, because we're protecting you by making me be licensed. Likewise, with concealed carry permits, it's a licensed conduct that the government has, the legislature has said, this is important enough that you need a permit to do what you're doing. And it's a valid exercise of police power. So we're going to protect you under valid exercise of police power, but we won't tell you who those people are.
Jennifer.
Pretzel logic.
Yeah. The Virginia Coalition for Open Government was also very involved in this discussion. I testified a couple dozen times this session on this issue. And our stance was that we had worked on a bill in the FOIA Council the previous year. Last summer I went to 9 meetings in the middle of the summer, took significant time out of my day, and they had been working on it even before that, to come up with a balance on that issue. And the balance that we decided was that yes, you had a public right to know issue at the local level. Again, I would flip that protection issue on its head, and I would say if my stalker, I would want to go down there and find out if he or she was carrying a gun, or if my ex-husband, who perhaps used to beat me, I would want to know. So we decided at the local level it would be open, but it would take some work. You'd have to go to your individual courthouse and look these people up. But we would close down the database because that was frankly a convenience issue, and it was more actually used by, as was pointed out, gun rights groups to get the names and addresses of gun holders to use for commercial purposes. So we tried to find a balance. What happened when we got in the discussion in the General Assembly was the balance got thrown all out of whack, frankly. And there was many discussions on closing it out, the information out completely. I think one thing that for some reason I didn't hear anyone say, and I don't know why no one talks about this, is for the domestic violence victims and the people with stalkers and all those people that I'm very sensitive to as a former advocate for rape victims, there is a process for sealing your permit. You go to a judge and you ask them. Okay, so I don't want you to think I'm advocating for information of those victims to be out there, because I'm not. But I do think that there is a definite public right to know on the concealed carry issue that comes from history and comes from the issue itself.
Last question.
A.J. Jones, Gainesville District. Based on your experiences and subtracting the legal reasons for not releasing information, why do our elected officials or our government officials have any hesitancy towards releasing it?
You mean information in general?
In general, or in specific? Why do they throw up roadblocks? What's the rationale behind it? What has your experience told you?
Do we want to jump on that one before I dump pessimism all over the place?
Well, I certainly can't speak generally. The elected officials rarely get involved in responding to FOIA requests unless it is for records that relate particularly to them, their emails or something of that nature. I've not actually experienced a tremendous reluctance to release records that are otherwise not being kept confidential pursuant to one of the exemptions for a particular purpose. We routinely release records that are not subject to an exemption with alacrity. It's where you have an exemption, there's generally a reason for the exemption, and it may be, for example, personnel records. They're simply not going to generally be released unless there's a good purpose for it. And if there is a good purpose for somebody else obtaining those records, they're generally available through mechanisms other than FOIA. For example, if a person's personnel record becomes relevant in a lawsuit, which happens, it's certainly subject to discovery under the general rules for discovery in court, or to subpoena, and so they're available in that fashion, but they're not available to everybody in the public. I don't know whether that answers your question or not.
No, because it doesn't include secret meetings. FOIA is more than just handing out documents.
Well, all right. Why do we have meetings that are not open to the public?
Why are meetings held which are in violation of FOIA? Why do liars lie?
I think the question is more directed. Cheryl's probably right.
I think, for my part, I've seen a lot of failure of government officials to be aware of FOIA laws. I've also seen a lot of, tossing off that it's not my job, speak to my attorney. I have nothing to do with FOIA. I don't need to learn this. You need to speak with the, governing body's attorney. I see that as a fundamental arrogance. If you can't be bothered as a government official who's put in a position of trust, whether you believe that God put you there or the people elected you, if you can't be bothered to learn, 30 pages of law that even a simple reporter can learn, then that's just arrogance. And, I think the people need to rethink the people who are put in those positions of authority and power, and consider how they treat FOIA requests as part and parcel of rating how they act as a government official. And I think that needs to be a serious consideration on the part of the people.
I have never met a public official put in their position by God yet, but I've met a surprising number of them that think they were. I want to thank our 5 excellent panelists. If we could please give them